Hi, I'm Terry Woods. I'm a lawyer with Legal Aid of East Tennessee in Knoxville, and I'm the pro bono director. So I want to turn this over first to Brad Morgan so he can explain why the pro bono director is particularly interested in welcoming you and thanking you for participating in this.
Sure, thank you, Terry. I appreciate that. And just as Terry mentioned, we want to thank you for viewing this video, for participating in this video series. My name is Brad Morgan. I serve as the Access to Justice coordinator at the University of Tennessee College of Law. I also am a member of the Tennessee Bar Association Access to Justice Committee. And this video that we're working on today is just part of a series of videos that are being produced in partnership between the Tennessee Bar Association and the Tennessee Access to Justice Commission in order to provide education and some practical advice to attorneys throughout Tennessee that are interested in performing services on behalf of indigent clients, whether it be pro bono service or low bono, just to acquaint attorneys with some of the issues that frequently are encountered by individuals of modest means. And we're very grateful to the Tennessee Bar Association, to the Tennessee Access to Justice Commission, to the Tennessee Supreme Court for allowing us the opportunity to participate in these videos. And with that, we'll go ahead and we'll turn the time back over to Terry to begin today's presentation to talk about issues that are frequently encountered in representing consumers in consumer debt-related issues. So Terry, thank you very much for the opportunity to be here with you today. I look forward to hearing what you have to say.
Thanks, Brad. You wouldn't think that representing debtors and debt collection matters would be particularly lucrative, but this actually can be a way to a kind of a niche practice for some people. And when we get into the section that Brad is going to talk about on fair debt collection issues, that is particularly where the attorney's fee aspect comes in. But this is just going to be an overview of debt collection issues from the consumer's perspective. If you're deciding to get into this type of practice, then there are several indispensable resources that you want to consider. One is the National Consumer Law Center at nclc.org. They have an incredible amount of resources for you. There's about 20 volumes, a treatise set, and with any volume you'll get a free subscription to their email updates and newsletter. And they go into incredible detail on all the issues that we're going to talk about. Another resource is the National Association of Consumer Advocates at naca.net. Again, if you're interested in developing any kind of consumer defense practice, these are the two places to go first. Now, just to kind of get us started on the right foot, we all agree that we support a free market economy. That makes America prosper, but the free market relies on competition, and that only exists if the consumer understands what they're bargaining for. And the reality is that they don't. About 40% of Americans can't fill out a job application or a bank deposit slip. The complexity of the terms of any kind of credit transaction are far beyond the skill of even an educated consumer. And lenders don't exactly tailor their disclosures with Americans' literacy rates in mind. The average credit card application is written at an 8th grade reading level, which is about right, but the average credit card agreement is written for a third-year college student. There's no doubt that some debtors are just deadbeats. They're trying to game the system. But most of the delinquent debtors find themselves in that position for desperate situations. They've lost their job or their hours have been cut. There's been some kind of medical emergency or a divorce. Those are the top 3 reasons to run into consumer debt. Of course, a debt collector doesn't have any way of knowing whether a particular debtor is of the deadbeat variety or one who just simply can't make the payments. So this leads some collection agents to resort to some particularly unsavory tactics to encourage the recalcitrant debtor to turn over the assets that he's wrongly concealing. Some debt collectors testifying before Congress pulled back the curtain on what some of their practices were. They impersonated government prosecutors. They threatened the debtor with criminal charges unless their parents paid the debt. They would have a block party. This is where they call the neighbors and tell them that the debtor is under criminal investigation and ask the debtors to get the debtor to call in so they can help him out. An office party is a variation on that. Involves calling the co-workers of the debtor. They'll solicit post-dated checks, and the purpose of that is knowing that it won't be negotiable. They'll be able to use it to threaten a bad check prosecution. They've threatened to report foreign-born debtors to immigration authorities. They suggest that male debtors sell drugs to get money to pay the debt. They'll suggest female debtors engage in prostitution to get the money. So all of these things are going to be subject to regulation under federal law, and that's what Brad's going to talk about in a few minutes. But what we're going to talk about is just more generally ways to address those problems as they come up for your client. If these aggressive tactics don't work for a debt collector, then really the only remedy that they have is to bring a lawsuit. And most defendants don't know what's going to happen to them when they go to court. They're going to expect to run into some kind of very mean and intimidating judge, or they'll expect it to be the way it is in the movies. But what they're going to find is a big crowd of people all hanging around, and it doesn't look like anybody, sometimes doesn't look like anybody's in charge. And they're certainly not going to know where they fit into that mob. And it gets even more disturbing to the debtor in many counties where they start out on a debt collection case in General Sessions Court by the judge saying, or someone saying, go out in the hall and talk to the creditor's lawyer. Now, sometimes it'll be the judge who says that. Sometimes it'll be the creditor's lawyer who comes in before court starts and says, if you've got a debt with such and such creditor, come out in the hall and we'll talk about it. But the point from the perspective of the debtor or the defendant, who may or may not be the debtor, but the person who is alleged to owe the debt, from that person's perspective, it just looks like somebody in a suit has come out and said, go out in the hall and talk to the creditor's lawyer. And that person with the suit may believe that they're having a very reasonable conversation with that debtor, but to the debtor, it may look like the creditor's lawyer is being very intimidating. Again, we have to bear in mind that these debtors have often never even been in the courthouse. So I find that most people who leave the courtroom to talk to the creditor's lawyer wind up agreeing to an installment agreement. But they're already feeling intimidated, and they're very likely to agree to make payments on a plan that they will never be able to afford to pay. For most debtors, when they leave the courthouse, the main question they have is, what happened to my day in court? Because they probably never talked to a judge. So the obvious question for any responsible citizen is, does it really matter if they had a day in court? If these people owe their debt, then they need to pay their debt. But the issue for us as lawyers is a little different because the obvious issue for us is that we have to make sure that the law actually entitles that plaintiff to have a judgment against the debtor. So let's look at some of the defenses or how you would defend a debt collection case in General Sessions Court. Most of these cases are based on a sworn account, and that's by statute, TCA 245107. And in practice, this is the relevant part of the statute. An account with the plaintiff's notarized affidavit attached is conclusive proof of the debt unless the debtor denies the account or except as allowed under subsection B. Subsection B just says that the debtor may deny the debt, assert any defense, make any objection that they have, and the judge will then reset the case to another date to give the plaintiff time to get their proof together. The law used to require the debtor to make a formal sworn denial. It doesn't require that anymore, but some judges think it does. So we generally have our clients actually file a response. So you get the affidavit of sworn account that comes with the civil warrant. And the debtor or the creditor's lawyer is assuming that the debtor's not going to show up, because that is what happens in so many cases. They can just take a default judgment. And there's no point in having the proof that they need for the debt when they don't know who's going to be there and contest it and who's not. And a very small percentage actually contest it, even if they're present. Most of those present will just enter into a payment plan. So they don't have their proof ready. So then the statute allows, and this is what we have our clients do, is actually file a written sworn denial that tells the judge and the creditor's lawyer that there's going to be a trial, and they have a chance then to go get their evidence together. Now, in this example, the debtor is saying that she doesn't owe the money and never had an account with this plaintiff. Believe it or not, we see this a lot at legal aid, some people assume that a court would not let the creditor sue them if they didn't owe a debt. I don't know how they think that the court is going to control that, but a lot of people actually believe that. So they come into it they don't even recognize the plaintiff's name, but they assume they must owe the debt. Now, if the plaintiff is the original creditor, then the defendant is probably going to recognize that name, but sometimes they'll say that they don't remember it. And it's perfectly legitimate to have a sworn denial that says, I'm not aware of a debt that I owe to this company. Now, if the defendant knows the plaintiff, there's still no way that that defendant knows how much he or she owes. The way interest rates, late fees, add-on fees, with the way those are calculated, it's impossible for a defendant to be sure that the amount that's claimed in the civil warrant is accurate. So the debtor can say, I may owe a debt to this plaintiff, but I still want the plaintiff to prove that the amount that I owe, and I reserve the right to bring up any defenses. Now, if the plaintiff is not the original creditor, then, in my opinion, you should always file a sworn denial. So in this case, we're looking at a plaintiff that is a debt buyer, not the original creditor, and the sworn denial can just say, I've never had an account with that company. The reason that I think they should always file a sworn denial in these cases when the suit is brought by someone other than the original creditor is that it happens all too frequently that the original creditor or some later assignee in the chain of the debt will sell it twice. So there's a very real risk, and we've seen this happen, of the plaintiff being sued twice for the same debt. And there have been a couple of cases where the appellate courts have said that's really awful, but there's not anything we can do about it. So if you've got a sworn denial that, for example, says I had an account with Bank of America, but I don't know if this plaintiff who sued me now owns this account. So I want that plaintiff to prove that that they have an interest in the account. I'm not aware of the amount that I owed Bank of America, so I want the plaintiff to provide records that show the amount. You might also file a sworn denial just to assert a defense, like the statute of limitations. So let's look at some of the common defenses that you can assert. It is not at all uncommon for a creditor to lose track of a debtor. So the lawsuit in this case is against Joan Doe. Well, Joan Doe might owe the debt to that creditor, but the defendant might not be the same Jane Doe that owes the debt. The debt might be in the actual defendant's name, but it might not have been opened by the defendant because there had been some identity theft issue. Remember that the person who used the card, even as an authorized user, may not be the card holder, and generally the authorized user, if not the card holder, is not responsible for the debt. You also have to be careful with spouses. The spouse who is not the card holder and has no contractual liability on the debt may still be liable under the doctrine of necessaries, but you've got to look at what the charges were to make sure that it's going to come under the doctrine of necessaries, to see if that spouse that's been sued who is not the account owner is the right party. As I said, the statute of limitations is frequently a defense that you can raise. There's a 4-year statute of limitation on the purchase of goods and lease of goods. That's under the UCC. It would apply to an auto loan, for example, even if the loan were originated by the dealer and sold to a bank after the fact, or an auto lease, deficiency on a repossession. And the cause of action accrues on the date of the breach, and that under the UCC is regardless of whether the creditor is aware of the breach. There is a 10-year statute of limitation on demand notes. That accrual time is the date that the note is signed, but the debtor may be making installment payments, and each time the debtor fails to make an installment, that's a separate cause of action, and the statute runs from the date of each installment. Most of the time you're going to run into a 6-year statute of limitations. That's going to apply to services like medical bills or credit card debts. Those are the most typical. The accrual date is the date that the installment or the note is due. If it's a type of debt where the creditor accelerated the maturity date, then the cause of action accrues on the date of acceleration. Remember that the statute of limitations is an affirmative defense. The court's not going to just recognize it because it's obvious. You have to raise it yourself, and the debtor should raise that as soon as possible. It's up to the trial court whether the debtor can raise it after the trial begins. Usually in sessions court, you can do that since no answer is required. Statute of limitations can be told. One way is by military service. That applies to the service members and their estate. It does not apply to co-debtors. The statute is also told when the defendant is out of state. And out of state means that during the time that the person was out of state, it was impracticable at all points during that time to get service of process. Now, the way that a typical credit card debt is collected after 6 years from the date of the last payment, that the last payment was due, which is the accrual date, is that the statute of limitations is revived. And it's revived if the debtor goes back to the beginning, the 6 year starts over again, if the debtor acknowledges the debt and expresses a willingness to pay it. So every time a debtor makes a $10 payment on a credit card debt, they have potentially started the statute of limitations over again. But the case law says that partial payment might not be an acknowledgement of a willingness to pay. It could be a compromise offer. So you have to look at the details of the circumstances under which these partial payments were made if it's been 6 years from the date of the last due date. Now, latches, of course, is the equitable version of the statute of limitations, and it allows a court to refuse to enforce a contract if there has been an unreasonable delay by the creditor. And defining what too long means in bringing the suit, you have to look at the lapse of time as well as prejudice to the debtor. So, for example, evidence could be compromised by this delay. There have been cases where the judges said, under the circumstances, because you've waited so long and you knew that the debtor was not able to pay, you've known that for some time, but you didn't bring suit. Now the witnesses that might have been able to help the debtor have died, or there's been a failure of memory or some other issue that's prejudicial to the defendant. It isn't necessary that the defendant show that there has been an affirmative injury caused by the delay, but the court can still bar the claim if the plaintiff can show that it's harder for the defendant to produce evidence that would have been available had there been a timely hearing. It's going to be a hard sell to defeat a debt on the basis of latches, but it is something that's out there. In states where there are some modern, we don't have many modern decisions on this in Tennessee, but some states do, and what those courts have found significant is that the creditor knew that the debtor couldn't pay. For example, the debtor told him they were unemployed. The plaintiff continued to add fees, like an over-limit fee, and interest was accumulating at the contract rate, which let's say was 29%, but a post-judgment interest, well, would have been 10% under the old statute. Now, of course, we have an adjustable post-judgment interest rate, but it's still going to be less than the contract rate. So the creditor is unreasonably delaying, and that is causing a measurable injury to the debtor. You have assigned or purchased debts. That creates probably the easiest defense. We referred to that problem a minute ago in the context of a debtor being sued twice for the same debt. That's how this comes up. The sale of a consumer account usually starts with the original creditor charging off the debt. And this is an enormous business. I've certainly have had clients who tell me that they looked at their credit report, the debt was charged off, they thought that meant they didn't have to pay it anymore. So they're quite surprised when a collection agency shows up and tries to collect the debt. Well, charging off the debt just means that the creditor has removed the value of the loan from its books and charged against loss reserves, but the charged off debt is still fully recoverable. Now, one of the big debt buyers, credit card reseller, it's interesting because when you go to their website, you can see various portfolios, and the one that captured my interest it's a portfolio that has credit card debts and also other types of consumer loans. They had over 4,500 accounts worth almost $14 million. And it shows the average charge-off date, which you'll see is the average charge-off date was in 2006, which is past the statute of limitations. So I'm sure the debtor wasn't making payments when the original creditor charged it off, so you can be reasonably sure that it's been 6 years since the last payment to the original debtor. So original creditor. So unless this debtor has been making odd payments here and there, the statute of limitations has run on most of these debts. Now, not all debt buyers will pursue a time-barred debt, but the statute of limitations is not the only problem with this debt buying industry. First, how does the debt buyer prove that the debtor owes this debt? And how does the debt buyer prove that the debtor owes the debt to the debt buyer? In any of these debt collection cases, the first thing that the creditor has to do is get their records of the debt into evidence. And their records are hearsay, but it will come in under the business records exception to the hearsay rule, which is Tennessee Rule of Evidence 8036. At least that's what the debtor hopes, or the creditor hopes happens. Rule 8036 lists the threshold standards that you have to meet to get the record in. It has to be made at or near the time of the event, such as recording when a payment's received or posted. It was made by a person with knowledge and a duty to make the record. We don't have to go through all of the elements of that rule, just take a look at 8036. But look at the practical side of getting these records into evidence, assuming they meet all of the requirements that are set forth in the rule. The business record has to be authenticated by a witness who actually appears in court, that's usually the records custodian, or by an affidavit. And the elements of the affidavit are listed under Tennessee Rule of Evidence 90211. Now, often the plaintiff's witness lives in Denver or someplace, so it's more economical, instead of flying the records custodian in, they want to use an affidavit, typically. Although you can never be sure. Sometimes they will fly the person in from Denver, but normally it's going to be an affidavit. But the affidavit has to meet the requirements of 90211, which are similar. They practically track the requirements of the hearsay exception for business records under 8036. And remember that under 8036 or 90211, the record has to be made by a person with knowledge of the event and a business duty to record the event. And here's what's tricky about that for a plaintiff who is not the original creditor. The affidavit has to be made by a qualified person, and we typically kind of conversationally talk about that as the custodian of records. But note that a qualified person is someone familiar with the business's record-keeping system and has to be able to explain the record-keeping procedures. And that's whether the person is testifying in person or by an affidavit. So the difficulty that presents for a debt buyer is something that creditors, lawyers hate, debtor lawyers love, and that's a 2012 Tennessee Court of Appeals opinion, LVNB funding as assignee of Sears Gold MasterCard v. Mastall. So Mr. Mastall had an account, apparently, with a Sears Gold MasterCard. But there were a lot more parties involved, as it turned out. The Sears Gold MasterCard accounts were serviced by City Bank of South Dakota, which then bought the accounts, apparently from Sears, and then sold the accounts to Sherman Financial Group. Sherman Financial Group is the parent company of Resurgent Capital Services and LVNB Funding, who was the plaintiff. So the plaintiff defines itself in the pleading as the assignee of Sears Gold MasterCard. So now they've got to get in records of this MasterCard account through an affidavit or a live witness to show that Mastall actually incurred the debt. Well, their first witness was an employee. They actually had a live witness at the trial, and that was an employee of Resurgent Capital Services. And she said that Resurgent was the attorney-in-fact for LVNV, which is why she was able to testify for this plaintiff. Their witness, who was being used to introduce the evidence of the debt with the Sears MasterCard, first introduces an assignment from Citibank to Sherman Financial. So there are debts that Sherman Financial was buying from Citibank. Then there was a second agreement by which Sherman Financial sold the debts to LVNV. So now we've got the link between Citibank and LVNV. But the problem with these two assignments was that they didn't list Mastaw's debt, which is very common. The assignments in the bill of sale that the debt buyer will have access to will usually refer to it says we're purchasing the accounts that are shown on Exhibit A. But then they don't have the exhibit, or at least they don't produce it in court. Now, there are exceptions. One problem that the creditor has is they don't want to introduce this full exhibit because it has confidential information about other account holders that don't have anything to do with this lawsuit. So sometimes you'll get an exhibit and it'll have everything redacted except the specific debtor in this case. But the problem that you still have is it doesn't tie into the assignment. It just looks like a random piece of paper that has the debtor's address and the account number and the amount that is claimed. So you don't have any nexus between that and what the debt buyer actually purchased. So in Mastaw, the witness from Resurgent Capital introduced also an affidavit, and the affidavit was intended to show that Mastaw's debt was one of the debts that was purchased in these two assignments, the one first from Citibank to Sherman and then from Sherman to LVNV. And both of these affidavits were signed by Toby Griffin, who was identified. The court said, we don't know if that's a man or a woman, but we're going to assume it's a woman. So she identified herself as the authorized representative of LVNV funding. Then there was an affidavit in which she said she was the authorized representative of Sherman Financial. And remember, she needed two affidavits because, I guess, there were two different assignments, one in which Sherman bought the accounts and one in which LVNV bought the accounts. So these two affidavits were supposed to show that the defendant's accounts were part of those assignments. Then finally, the evidence that the plaintiff offered was a compilation of the defendant's credit card statements, just copies of the bills that were sent monthly. So this witness, whose sole purpose was to authenticate the business records, to get them in under the hearsay exception, said that she had no knowledge of Citibank's records. Of course, she didn't work for Citibank. She didn't know how a Sears MasterCard account was created, and she didn't know what Mr. Mastaw bought with the card. So obviously the issue that the Court of Appeals has to grapple with is this evidence admissible? And the court began its analysis with a very simple concept. First, the plaintiff has the burden to prove that there is a debt, that the defendant owes the debt, has to prove the amount of the debt, and that the plaintiff owns the debt, or that the defendant, if he owes the debt, owes it to the plaintiff. With regard to that last item about whether the plaintiff owns the debt, the court in Mastaw quoted from a Missouri case that required a plaintiff to account for every link in the chain between the party to which the debt was originally owed and the party trying to collect the debt, and to prove each link by competent evidence in order to demonstrate standing. So if you couldn't complete the chain, there was no standing to sue on the debt. Now, nobody in this case disputed that the business records were hearsay. The issue was whether they could be admitted under the exception, the business records exception to the hearsay rule. And the court noted that the purpose of the business records exception was that properly kept business records are inherently trustworthy. But specifically, were Toby Griffin's affidavits trustworthy? Because they were being introduced by this live witness, the affidavits were being introduced as evidence themselves. And because those were the only way to link the plaintiff with the defendant's alleged debt. So Griffin said she was an authorized representative, but it didn't say what that meant. And it didn't explain how she was an authorized representative for both LVNV and Sherman Capital. And remember, the person authenticating the records has to be somebody with some knowledge about the records. Authorized representative doesn't really tell the court anything. The affidavit also didn't explain what records she actually examined, and it didn't attach the records, which I can't even tell you how common that is. I hardly ever see the actual records attached to the affidavit. And then the affidavit said that the records included information from the original creditor, but it didn't say who at the original creditor's business created the records or how they were kept or anything else that would indicate that they were reliable or authenticate the records in any way for this company that she didn't work for. For example, one of the elements of the business records exception is that the record has to be made at or near the time of the event. So that means it's made by a person with knowledge of the event, a business duty to record the event. Well, there was one case that said, not the Mastall case, but a different one, where the debt buyer's custodian of records testified that he was familiar with the original creditor's business practices, but he couldn't testify that he had received any instructions about their record-keeping system, and he couldn't say that he had actually checked the reliability of that original creditor's data. So the court found that he wasn't really able to authenticate the original creditor's records. Now that is a Vermont case, but it says it very well. They didn't have to address that issue in the Mastall case by the Tennessee Court of Appeals because the questions were whether the affidavits themselves were business records. So to be a business record, it has to be made in the ordinary course of business. But Griffin's affidavits were made for the purpose of litigation. They were not business records, so they weren't admissible just because of that. That's why the court didn't get into whether she had knowledge of the actual content of what was in the affidavits. So Resurgent Capital, testifying on behalf of the actual plaintiff, LVNV, has this evidence. They've got the assignment and assumption agreements that show that a group of debts went from Citibank to Sherman Financial to LVNV. Then they've got an affidavit that shows that they owned, that the defendant's account was within the group of debts that were assigned. But those affidavits were inadmissible because it wasn't the affidavit itself was not a business record. The other evidence that they had was the compilation of the defendant's credit card statements that were either from Citibank or Sears. That wasn't clear. But there's no link between those statements and the plaintiff. So there's no link between the debt and the plaintiff. And there's no evidence of the amount of the debt because they haven't gotten the business records from the original creditor into evidence. Now, LVNV did have one other witness, and that was the defendant, who was not at all helpful because he didn't remember anything. In fact, he might have even paid off that debt. And it's worth noting that a defendant does not have to be present in court. The creditor can subpoena the defendant, and as the courts have said, the defendant can take his chances by not being there to rebut evidence, but just the fact that he doesn't show up if he's represented by counsel and counsel proceeds with the trial, that's okay. That doesn't put that defendant in default. So again, we're looking at the trustworthiness of these business records that come from a source other than the original plaintiff, and you see all sorts of efforts to get this in. I had one where the creditor gave an affidavit that said the account had been transferred to the debt collector, who was the plaintiff, in July of 2007. Then another statement that they produced said that it was transferred in March of 2007. Well, if there are internal inconsistencies in the records, that is an indication of their not being trustworthy. And all of the business records exception hinges on the trustworthiness of these records. I had a case where they gave me an affidavit that said that the original contract had been destroyed and is no longer accessible, and this affidavit is to be treated as the original document, and there is a statute about when you have lost documents. Except then they produced the document. After they said that it had been lost, they actually gave a copy of what they purported to be the contract. The problem was that my client's account was opened in 2002 with Fleet Bank, but the contract they produced had a copyright notice from MB&A for 1996. Now, you might say, well, maybe MB&A acquired Fleet Bank by 2002, and they were still using their 1996 forms. Well, that might have been a legitimate argument, except that they said in their own records that that was not the case. In 1996, MB&A created the contract. Then MB&A became FIA Card Services, who I believe was the named plaintiff in that case. Meanwhile, unrelated to either of those entities, Fleet Bank opened the defendant's account. Fleet Bank merged in 2005 with Bank of America, and in 2006, Bank of America acquired FIA Card Services. So there is no connection in that chain between MB&A and my client's Fleet Bank account. So no reason that she would have ever had a 1996 contract from MB&A. Now, it's very common for the plaintiff to rely on these monthly account statements as evidence, and it'll give all sorts of information. But it's only information that says what the creditor said that the debtor owed at any particular point in time. So let's say that you get a statement, and I've never gotten a set of statements that begin with the first one where they opened the account. They'll start several years after the client opened the account. So there'll always be a beginning balance, but you don't know how they got to that beginning balance. And then usually they'll give you a couple around any particular date, say 2002, and then they'll skip a few years and you'll get a few statements from 2004, and then they'll skip a few more years and you'll get some from 2006. And then it'll stop whenever the original creditor wrote off the debt. But it's very rare to see a complete set of the credit card statements. So again, starting with that $4,000 balance doesn't prove that anybody incurred it. It just says that the creditor asserts that that's what the debt was. Then you may see additional charges. Well, let's say in this case, the client shows a charge of $1,500 for auto repairs. And you'll see a payment. Well, that payment will be applied to the previous balance if it's on the same monthly account statement. But for purposes of accounting, if you're disputing the amount that the debtor owes, it needs to apply only to that $1,500 because that's the only debt that's actually been shown. And that's if you've got the defendant there to admit that, yes, she made that charge if she's present in court that day. And all of this ties back into the interest rate because the monthly statements will usually show different interest rates. It might be 28%, it might be, a few years earlier it was 14%, then it'll go back up to 29%. So you've got to calculate whether the creditor actually charged the right interest rate, and it's very complicated to figure out from the credit card agreement how they do that. And did that previous balance or any subsequent balance that's appearing that you can't account for by actual charges and payments on the credit card statements, did they properly charge late fees? Because I always, almost inevitably find that they charge late fees when a payment has been posted before the grace period's over. So you've got to check all these things to be sure that they've accounted for it all correctly. So you've got the calculation of these finance charges, and that's not something that anybody looks forward to trying to calculate, but one agreement, this is pretty typical. It says this credit card agreement consists of this document and the terms and conditions set forth in the required federal disclosure section of the accompanying card carrier, which is incorporated herein and made a part hereof, which is great, except that the accompanying card carrier statement isn't there. So you've got boilerplate credit card agreement that says your actual interest rate and what you'll pay for late fees and all these other add-ons. That's in a separate document that's attached. Well, I don't know if it was ever attached or not, but it's certainly not part of what the creditor has given me as evidence of the debt. So without those actual terms and conditions, there's no way for me to calculate whether the payments have been allocated correctly. Now, a lot of times they'll change the terms in midstream. So after the debtor has gotten a credit card, most of the time the creditor has a right to change the terms. And if the debtor uses the credit card after being notified of the change of terms, then they are assenting to the change of terms. Now, the change of terms usually comes as an insert with the monthly bill, and here's an example of one. It says, enclosed with this statement, you will find a document entitled Important Notice of Change of Terms. That document, together with the terms below, constitute your new credit card agreement, and that completely replaces your existing agreement. Please see the corresponding sections of the enclosed credit card agreement for additional terms. But once again, I don't ever get that. When the plaintiff is giving me their evidence, they don't ever have the actual terms. And this is important because, for example, this was in one agreement I had, Section 8, when periodic rate finance charges begin to accrue. See enclosed credit card agreement for complete terms. So when do they accrue? I don't know because they didn't give me the credit card agreement. Later it said annual fee. If you have an annual fee on your account, well, I don't know because they didn't give me that document. So again, these monthly account statements, they don't tell you what the debtor agreed to pay. They only tell you what the creditor says the debtor owes at a particular point in time. Now, the creditors bar has gotten pretty excited lately over this concept of an account stated. And what that means is that there has been an agreement, express or implied, as to the amount due. And these, according to Tennessee courts, are the elements of the cause of action for an account stated. You've had prior dealings on an open account. There is an agreement between the debtor and the creditor on the amount due. And there is a specific and unconditional acknowledgement of the obligation by the debtor. So the creditors bar is saying they've gotten these monthly statements and they never objected to them. And they'll always say, if they get the debtor to testify, they'll show them an account statement and say, is this your address? Do you get mail at this address? So that's supposed to prove they got the statement, but they never objected to it. But the problem is that at most, when the debtor doesn't object to the balance that's on a monthly statement, that would prove the amount of the debt. But it wouldn't establish that the defendant was liable for the debt And it wouldn't establish that the plaintiff had the right to collect the debt. So another thing to look at on these, especially if they're making an account stated argument, is look at the various numbers that the creditor gives you. There'll probably be one balance due on the most recent account statement that they give you, which could be completely different from the amount that's shown on the civil warrant that they've sued for. And sometimes that's even different from the affidavit that they attach to the civil warrant to make it a sworn account. So if they can't agree on the amount, then it certainly can't be an amount stated. One court, I think, expressed this pretty well when it said it's reasonable to assume that most credit card holders have never attempted to read the entire initial cardholder agreement. Furthermore, even if they attempted to do so, it's unlikely they would have understood what they read. And I find it difficult to understand, and I'm sure my clients do as well. Another great defense on these cases is the Collection Service Act. The Collection Service Act defines a collection service as an entity that engages in debt collection, whether the service is an assignee or purchaser of the debt. So if the original creditor is trying to collect their own debt, they're not subject to this Collection Service Act. But if it's a debt that's been assigned or purchased to somebody else, then that assignee or purchaser is subject to the Act. And what the Act says is that no person shall commence, conduct, or operate any collection service business unless they are licensed. And there's a collection service board that issues that license. Now, the creditors bar has really focused on something that is on the board's website. And it says entities who do not collect a purchase, debt, or judgment, but rather assign collection activities to a licensed collection agency or licensed attorney shall not be deemed to be a collection service. And what the creditors bar, what they're focusing on in that statement, again, it's just a statement on the website. They're saying entities that assign collection activity to a licensed attorney are not collection services, which by that interpretation of this statement on the website means that once the plaintiff has hired a lawyer, they're not a collection service, so they don't have to be licensed. Well, let's say that's true. That is not what the statute says, and a board that's charged with enforcing a statute can't change what the General Assembly has done. So even if that's what the board meant to do, they didn't have the authority to do it. But second, you have to look at the context of this statement. The title of it is Clarification Statement of the Tennessee Collection Service Board regarding debt judgment purchasers and passive debt buyers. Now, there's no definition of a passive debt buyer anywhere. But when you have a creditor who's asserting this statement on the website as their defense to your argument that they don't have standing to bring this lawsuit because they're not licensed, they're going to say, well, we're just a passive debt buyer because we hired a lawyer. The term passive debt buyer comes from a bankruptcy case from East Tennessee, N. Ray Rogers. And that involved a company that never had contact with debtors. All they did was buy accounts that were actually in bankruptcy. I don't know how they made a lot of money off of this, but that was their business model. So all they did was file a notice of claim with the bankruptcy court against the bankruptcy estate, not against the debtor. So Judge Stayer said they're not subject to being licensed. They're passive debt collectors. That's fine. If you have somebody who's doing that, you're only going to see them in bankruptcy court, and they may have a legitimate argument. But anybody who is proceeding in General Sessions Court is going directly against the debtor, and they're not passive. Another thing to consider is if that interpretation of the statement on the website were what the creditors bar wants it to be, then who does it apply to? It could only apply to an individual because everybody else has to have a lawyer. That's the only way they're going to get to appear before the court. So it's nonsensical to think, since this company must have a lawyer to sue, that the law exempts anybody with a lawyer from having to be licensed. You also have a provision in the debt collection statute itself that says no collection service licensee shall commence any litigation authorized by this section unless represented by a lawyer. So that's pretty clear. They anticipated that all of the debt collectors would be represented by a lawyer. They did not anticipate that having a lawyer would exempt them from being licensed. Finally, there's a Tennessee Attorney General's opinion that said that even lawyers who are licensed, who work for a collection service agency, have to have their own license as a collection service agency if they're operating a debt collection service apart from their law firm. Okay, those are some of the defenses. They're not always going to work. Sometimes you're going to have a debtor who gets a judgment against them. So just briefly, I want to go over some of the things to consider when you're protecting a judgment debtor. First, they need to file a notice of exempt property. Regardless of how little they have, it's a good idea for them to do that. They can include things like an anticipated income tax return, bank accounts, obviously, car, that's the main thing they usually want to protect. But file that notice. In Knox County, I think it costs $4. You shouldn't automatically advise a debtor to file a motion to pay by installments. If you've got a debtor who is judgment proof, then it's hard to find a reason to file a motion to pay by installments. If somebody is living on $675 a month of SSI, then they can't afford to make an installment payment unless they stop buying food or stop paying their rent. And I've had clients do that. So they shouldn't be making an installment plan that they probably can't keep anyway. It's also a good idea to warn debtors about post-judgment inquiries, that they may get a subpoena that asks them for financial records and tell them they have to go to court to respond to that, lest they be held in contempt. And finally, just try to reassure them that failing to pay their credit card debt is not going to send them to jail, because that's what I find to be their primary concern, because debt collectors have told them that they can go to jail. And with that, it's probably good to turn this over to Brad, and he can talk about some of the other abuses and the fact that you can't go to jail for that sort of thing.